Okay, so Frank Greaney is with us. Good morning to you, Frank.
Morning, Ger.
On the front pages of most of the newspapers today is details of the bits of the rape trial in Belfast that gripped the nation that weren't shared with the jury. So just to clarify, what happens here is legal argument happens, the jury are removed from the courtroom, and then they come back, and whatever decision the court has come to about evidence or anything else is then, it's almost like it never happened for the jury. They have to kind of blank, oh, why were we asked to leave? Oh, we're back. I wonder what happened there.
Yeah, and there's a good reason for it, and it's not that unusual, particularly in a trial of that duration. 9 weeks, it's not that unusual that there would be a lot of days taken up by legal argument. Indeed, that was the case here. And the reason, I suppose, that the jury is asked to step out is because legal issues that are being trashed out in their absence could potentially be prejudicial to a defendant's case. So we're not allowed to report on them while the trial is in session. But afterwards, normally those restrictions then fall away. That didn't happen here because the judge, Patricia Smith, put a specific court order in place preventing us from publishing or broadcasting those details in any way. And the media actually had to fight to have that order lifted. Now, the way things panned out yesterday, the media were represented in court and did make an application to have that order lifted. But in the end, there were no objections, so we were then allowed to publish those details.
It's unusual that a judge would ask for that delay in details like this. Was there any reason, did she give a reason what her motivation for that was?
No, she didn't. It was an order that was put in immediately after the verdicts came in, and there was actually an initial media application, and she decided to put it back to listen to it again. It's very unusual, but I suppose this particular court, Belfast Crown Court, is probably more accustomed to dealing with non-jury cases, cases of a paramilitary nature, for example. I mean, the dock itself can seat 20 people, and that's because it's more accustomed to dealing with those kinds of cases. So maybe she was just unfamiliar with the territory. There's no legislative provision for not reporting legal argument. It was brought to her attention. Some members from the press gallery, myself excluded, actually asked for clarification on that issue, and she wasn't sure, so she decided the best course of action was to put this court order in place. It was always going to be a temporary one, and it was always going to be resisted.
One thing, and I don't know if you know the answer to this or not, is like, obviously that is a separate jurisdiction, they have a separate set of laws. Why were the media organisations in the Republic of Ireland bound by those reporting restrictions? I didn't quite understand that the whole way along.
Well, there would be if we had breached that court order down south. I mean, we would have been in contempt of court, albeit in another jurisdiction, and they may not have actually sought to have us appear before Judge Patricia Smith.
However, you don't take that risk.
You don't take that risk.
Taking the risk.
Yeah, and also from a professional point of view, for me it boiled down to respect for the court, and I knew that there was going to be an application to have that order lifted. And also you have to remember the amount of media attention that the verdicts themselves got, and the days and weeks indeed afterwards. It's been just a little over 2 weeks since those acquittals came in. So maybe at the time it wouldn't have been appropriate to talk about what the jury didn't hear, because that would have just been lost in the white noise that surrounded the verdicts themselves.
Potentially, like, getting it all out there at that point would have stopped the conversation. The conversation would have finished or moved on to where it probably needs to go about how these trials are run. Now it's brought it all back up again, and suddenly it's literally on the front page of most of the newspapers today. People talking about blood on Paddy Jackson's sheets, people talking about a spit roasting in inverted commas clip that was sent by
Rory Harrison to Stuart Olding. Yeah. The jury weren't showing that. That was something that was the subject of legal argument. Obviously, that's why we're talking about it. And I suppose the reason that it was excluded was it boiled down to relevance. The judge decided in the end that because there was no text or caption accompanying that video, there was also no proof that Stuart Olding had opened and viewed that video. And the judge said that she did accept the prosecution's case, that there may be some relevance to their case, and the point that they were making was that it was sent 2 hours after this meeting that they had, this lunch that they had in Soul Food Cafe on the afternoon of the alleged incident, some hours after the woman had claimed that she had been raped by Paddy Jackson and Stuart Olding. And the prosecution claimed that video proved one of their theories, or at least supported it, that they had discussed what happened that night and that they had concocted a story. The judge felt that it would have been unfair to allow that in as evidence to the jury because there was no text or caption to put it into context. The defence argued that it was a legal pornographic video that showed a woman engaging in a consensual threesome.
Yeah, so it was basically a clip of porn. It wasn't actually any kind of, the people were unknown to everybody in court.
That's right, and also Paddy Jackson's barrister said that if that video was allowed to go to the jury, then he would have had no choice but to scour the internet for other videos, pornographic videos that would have supported their case. The issue was over the exact, and I know it's early in the morning so I don't want to get into it, but the exact mechanics of what a spit roast is and what his defendant, Paddy Jackson, thought it was.
Yeah, I mean, some of the legal argument. There was also the policing of the tone of the closing remarks, which I found kind of remarkable. It was like they were criticising the judge on instruction, of course, and with a heavy heart, they said. But they were like, "Oh, you were too kind to the woman. Basically, you were too kind to the complainant, and you read our stuff really fast." It was like, I mean,
I thought it was unfair.
It's astonishing.
It is. I've never seen it.
Would it have happened to a male judge, I wonder?
Well, listen, I don't know, but he did say that he was acting on instruction, so we
from
had
who?
to. That would have been his code for, yeah, it's an instruction from his client or possibly his solicitor.
Right.
I thought it was unfair because I was sitting there. Now, tone, demeanour, things like this are subjective, and that's the reason we don't talk about how a witness behaves in the witness box while a trial is ongoing, because my perception of how the complainant was responding to cross-examination, for example, didn't really matter a damn. It only mattered what the men and women of the jury felt and thought about her evidence, body language, things like that. It's always very subjective. I was listening carefully to Judge Patricia Smith, who I felt handled a very difficult case very well, and she was commendable for the way that she handled the case. And I thought she was very fair in her final charge to the jurors. It's twofold. She's summing up evidence for the jurors, as she's also going through the various legal principles. And the argument that Brendan Kelly was making on behalf of his client was that whenever she spoke about evidence relating to the complainant, like her witness statements, for example, he claimed that she was pushing on a sympathetic tone, and that sympathetic tone wasn't existent when she was talking about his client, Paddy Jackson. I thought it was unfair, and she, for the first time in the long trial, she became agitated. She didn't take that very well. She did accept the views of him and Stuart Olding's barrister, Frank O'Donoghue, who rode in behind him, and said that he also felt that the way that she was describing the complainant's evidence was a different tone was being struck. In the end, she rejected their arguments, but she did agree to moderate her tone and to deliver it at a slower pace, and she did that from there on in.
Just in terms of the evidence where it could be perceived one way or not, and that they ultimately decide that this isn't going to aid the jury in any way whatsoever, like happened with the pornographic video here. Like, I understand there was some talk about a potential slang expert being brought into court, and that was eventually shelved. Was that for the same reason?
Exactly, yes. There were a number of things that the lads spoke about in the text messages. They were explicit. We won't go through them again this morning. They've been spoken at great length, and that was one thing that was brought up in legal argument, that there was some toing and froing about whether or not they would call in a slang expert. In the end, I think the prosecution simply decided that they chose not to, and it wasn't an issue for the judge to have to rule on. But that's just a prime example of these things that happen behind, not necessarily behind closed doors, because the media are there and usually allowed broadcast these things immediately afterwards. But obviously that would have been something that the jury would have been unaware of, and again they didn't hear from this particular expert. And
not even just with this case, just with law in general at the moment, do you find that there's kind of a shift towards a grey area? Because I think the one example from this case was one of the barristers questioning the complainant about the use of the upside down smiley emoji, which naturally you're questioning, what does this mean? That there isn't a definition for this sort of thing. Do you feel that, like essentially, as I say there, that legal argument has moved more towards the grey area as a result of things like emojis? It's a good question. Like, that wasn't something that was actually discussed during legal argument. I mean, one person's perception, and the witness was asked what she thought an upside down smiley face was, because they thought it was actually quite unusual. The first mention to her friend that she'd been raped was followed up by these upside down smiley face emojis. I'll be honest with you, I didn't know what that emoji meant. I don't think that I've ever used it myself, but she was asked about it, and she said it was like when things go wrong.
that was unfamiliar to me. The jury were told that in session. That wasn't something that was thrashed out in legal argument. But to speak about grey areas, I suppose like the prosecution would have had to prove its case beyond a reasonable doubt, and a good defence barrister then doesn't have to defend a case at all, because it's entirely the burden of proof is entirely on the prosecution. But I mean, a good defence barrister will raise question marks over evidence, will unanswered questions go into a jury reasonable doubt. If you lay in bed at night after making a decision and you're not comfortable with it, well, that's a reasonable doubt. And Brendan Kelly in particular was forensic in his handling of the case, particularly during cross-examination, and particularly in his closing speeches, where he went through 16 chapters in his closing speech, and all he did throughout was raise question marks over every single piece of evidence that the prosecution presented. And we'll never know how the jury arrived at its decision, but clearly they weren't convinced that the prosecution had proven its case beyond a reasonable doubt.
Obviously, one of the jurors had taken to Broadsheet, the comment section of Broadsheet, in the aftermath of the trial, and is there any further developments on what's going to happen with that, or was that brought up in court yesterday when this...
No, it wasn't brought up in court yesterday, and it's probably, it wouldn't have been appropriate for it to be brought up in court yesterday, because that's now a police matter. It's up to them to investigate.
Is it a police matter that you serve in a jury and then you're no longer allowed to, you can't talk about what happened? Because I know, obviously in the States, it's this kind of, it's now this, I'm on the right trial, I'm going to get rich, I'm going to sell my story, and you hear exactly what happened in the jury room afterwards. But in the UK, you can't speak after you've been on a jury?
Yeah, not so. This particular juror could be held in contempt of court. So I know that
the case is over. That's like,
even though the case is over, yes. And I know it has been taken very seriously. Those comments that were made on Broadsheet that were taken down. After they were taken down, I understand that there was also some more online commentary from this particular juror just trying to outline her case, and I know she was expecting a call from the police, so it's now in their hands. I suspect that she may just be given, you know, a warning or a slap on the wrist. It may be considered unfair to bring her before the courts, but who knows? They do take these things very seriously.
Two other issues. There was blood on Paddy Jackson's sheets that didn't make the prosecution case. The blood was not the complainant's blood. Is that correct?
It was described in court as a non-related person. So no, it wasn't. It didn't belong to the complainant.
And this was obviously in photographs of the bedroom, which would have been part of the prosecution's case. What happened to those photographs?
So the prosecution wanted to show these photographs for obvious reasons. Not unusual in any case that photos of a potential crime scene would be shown to a jury. The prosecution wanted to show the photographs as they were, as the room was, as soon as the police began their investigation. The defence took exception with it because of that second stain belonging to this non-related person. Brendan Kelly argued successfully that to show the jury that second stain that didn't belong to the complainant would have been unfair, and he said that it would have been prejudicial to the trial as a whole. The prosecutor, Toby Hedworth, argued that point that I've just made, that the jury should be shown the bed sheets as accurately as they can be, given the fact that there were a couple of days, obviously, before a complaint was made by the woman in question. So the judge actually suggested airbrushing out that second set of stains, so that the photo that the jury would have been shown would have only shown the blood staining belonging to the complainant, and that was agreeable to both parties. One
other bit was that there was semen on the crotch of the jeans from Stuart Olding. That bit also wasn't conveyed to the precise landing spot of the semen wasn't conveyed to the jury.
Yes, that's right. So the woman's clothes were shown to the jurors, and we heard during the trial, and this was again accepted on both sides, that traces of Stuart Olding's semen were found on all of her items of clothing. The one thing that the jury wouldn't have been aware of, and this is because of something that happened in legal argument, would have been the exact location of those traces of semen, particularly the one that was found on the crotch of her white trousers. And the reason they weren't told that was because Frank O'Donoghue, who represented Stuart Olding throughout, argued that to tell them the exact location would have created an unfair suspicion in their minds. And this was because of something that the jury wouldn't have actually been aware of, this fact if it wasn't for him being so forthcoming with it, that Stuart Olding was initially charged with vaginal sex. That was dropped just before Christmas, and he stood trial for and was acquitted for a charge of oral rape. So Frank O'Donoghue argued that for the jury to be told where this stain was exactly on the trousers would have created this unfair suspicion. The judge agreed that that would have been unfair, so they were simply told that there was semen found on her trousers. One
of the other things that happened during the trial, obviously, was the hashtag #NotMyCaptain trending on Twitter for a sustained period of time in the aftermath of Rory Best, the Ireland rugby captain, showing up in the middle of the Six Nations on his off day at the trial. It was particularly pointed given the text messages or the WhatsApps sent from the complainant to her friends that she was actually going to be up against the might of Ulster Rugby. And Rory Best did show up alongside Ian Henderson, and we think Craig Gilroy was there as well, although he wasn't actually in the photograph that made the newspapers the next day. It was obviously a big issue. It trended on Twitter. The defence made the case that this would need to be addressed somehow by the court.
Yeah, and listen, I think the whole thing around Rory Best was a bit of a distraction from the important work that was happening in the courtroom. The public gallery was open. Rory Best was entitled to be there as a citizen of Northern Ireland. But aside from that, I understand why there was such a furore over it. You mentioned that hashtag campaign. My criticism, I suppose, criticism is maybe a strong word, but I thought if he had been, and I've no reason to think that he wasn't, but if he had been directed to be there by senior counsel, I don't know why that wasn't explained sooner than it was. It actually took some legal argument on behalf of Stuart Olding. Frank O'Donoghue got up and told the judge in the absence of the jury that it was in fact him that had instructed Rory Best to be there.
When you say instructed, right, like we can have a conversation here and I can instruct Owen to give me the cup of coffee, but like he doesn't have to do it. He's got free will. So like the Stuart Olding's barrister instructing Rory Best to do something has no power of compulsion. He's not an officer of the court. He's not a policeman.
No, and I think it would be unfair to suggest that he was compelling him to be there. Maybe advising would probably be a better word to use.
Was the message to the jury that he was advised to be there, or was that he was instructed to be there?
He was directed. I think was the
so
exact
there's
word that was used.
You know, I mean, they're lawyers and they're using these words like very carefully. We'll craft this word, but it seemed that the jury was like, oh, you can tell somebody to come here. That's like that they were. I'm not saying they were misled, but certainly I'm not entirely convinced that it was explained to them in a way that was straightforward. Yeah,
that's a fair point. And he did go to great length speaking about the backlash about Rory Best's attendance. And the point, and I suppose what angered him so much, was that Rory Best was only ever mentioned as a probable character witness. So was Ruan Pienaar, so was Leah McCourt, an MMA fighter that's quite close to Paddy Jackson. She lives up in Northern Ireland. Neither of those gave evidence either. And the concern that Frank O'Donoghue was making, and the reason he wanted to clear the air, I suppose, in some way with the jury, was that he was worried that what happened with Rory Best and the backlash that his attendance received on social media and elsewhere was that it would dissuade character witnesses from coming forward. We don't know why Rory Best decided not to give evidence in the end. It was never confirmed that he would give evidence. None of the character witnesses were confirmed. The jurors were simply told at the outset that they may hear from the likes of Rory Best and Ruan Pienaar and so on. So we will never know if other character witnesses were dissuaded.
That's interesting. I didn't realise that. So at the start, when the case is being laid out, the defence case lists out the people who they might at some point offer as character witnesses. And it's after that Rory Best appears in court, and it's after that the legal argument happens, where it's decided that the jury are then told that he was directed to be there. That's a sequence of events.
Yeah, so there are big differences between covering cases in Dublin and covering cases in Belfast, and it was a learning curve for me personally. I'd never covered a case in Northern Ireland before, and quite a baptism of fire given the high profile of this case and the level of interest in it. At the beginning of the trial, and this would also happen in Dublin, potential jurors, this is before they're sworn in, the jury panel will be told a list of witnesses, police officers, anybody that gave evidence during the trial. The jury would have been given their name initially, and they would have been advised not to sit on the jury if they knew any of those. That makes sense. If they knew the lead investigator, for example, it wouldn't be right for them to sit on a jury because they could potentially be influenced by it. Brendan Kelly then took to his feet after the prosecution had listed the 30-odd witnesses that they planned to call, and he told the jury panel that they may, and that word proved to be crucial, that they may hear from the likes of Rory Best, from Ruan Pinar, from Leah McCourt. Others were mentioned. Others did give evidence. Most didn't. So it's not that unusual. And then jurors would have indicated if they knew any of those people, and they obviously wouldn't have sat on the jury. So it's not unusual that that information would be relayed to them. The legal argument then would have obviously taken place in their absence. But when Rory Best and Ruan Pinar's names were first mentioned, it would have been, I suppose, technically at a pre-trial stage, which we cannot report on.
Right.
So we had a question ourselves in the press box. Can we now say at the very outset that Rory Best may give evidence? And the general consensus was no, that there could be a difficulty, that we could potentially be held in contempt. So there was no court order put in place, but the media decided that it was probably best not to mention the fact that those we mentioned. Rory Best then, by attending that day, well, that kind of secured his own fate, that people then knew that he was due to be called.
And sorry, just on the jury selection, is that straightforward? Is that like, or do they go through and kind of go, are you a fan of Ulster Rugby, therefore you're not allowed to come, or did you go to Methody, therefore you're not allowed, or is it? It's
a really good question, and the judge did spend some time, and this would have been something that was agreed with both the prosecution and the defence barristers, a list of conditions whereby if anybody, for example, had a season ticket to see Ulster Rugby, or was a fan of Ulster Rugby, or felt strongly one way or another in relation to the case, that they shouldn't sit. And indeed, some people took some time to go through that list, and there were other things, you mentioned schools, things like that, areas, if people were from certain areas of Belfast, they shouldn't sit on the jury. If they felt they couldn't approach it in an unbiased manner, they shouldn't sit on the jury, for example. And a number of witnesses, or a number of potential jurors, did say that they were Ulster fans, that some of them were season ticket holders, and they were obviously excused then because of the potential for bias.
Yeah. It's definitely the biggest, most covered trial that I can remember, like, since I was a kid. I don't know if we fully all appreciated just how big the trial and how much a discussion point the whole thing was going to be. You guys couldn't have guessed.
No, listen. I've been fortunate, or maybe unfortunate, enough to cover some high-profile trials. Graham Dwyer, for example, the murder trial. He was convicted of murdering Elaine O'Hara 3 years ago. Interestingly, the verdict came back in relation to his case the same week that it came back for Paddy Jackson, the acquittals for Paddy Jackson and his 3 co-accused. I initially went up to Belfast with the intention of staying there for the opening stages, the complainants' evidence, the cross-examination. And then trials generally have peaks and troughs, whereby interest in them will slip and you might come back towards the end, or if there's a key witness due to be called, you might go up and cover that. You'd certainly be there for closing stages and for when the verdict comes back. But I think it was clear from the very first day when Toby Hedworth stood up and gave a lengthy opening address and outlined the prosecution's case. He spoke about that Jacome group, the WhatsApp groups. He spoke about the specific allegation that was being made against Paddy Jackson and Stuart Olding. I spoke to the head of news, Sinead Spain, here at Newstalk, and it was very obvious from our conversation that I was going to be there for the duration. It was initially set down for 5 weeks. I was there for 9 weeks. I was overwhelmed by the amount of interest in it, to be honest. But I don't think, looking back, that it was that surprising. These were 2 very high-profile individuals. But it also raised other issues, lads' culture, the culture amongst guys in sporting circles, young people and how sexualised they are, pornography, things like that. I mean, 2 weeks on, we're still talking about it. I know that's just because it's splashed over the front pages again, but there are still conversations being held over, across dinner tables and at water coolers about issues like consent and important issues like those kind of things. So, listen, a lot of people will say that the coverage was overkill, that the explicitness of it shouldn't have been reported as extensively as it was. But I think there were important issues raised, and there was clearly a lot of interest in it.
No, you're dead right. You did great work, Frank. Thanks very much for covering it for us over the duration of it, and hopefully those conversations will continue, because really we can't talk about consent too much here.